This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're speaking about why a properly written reservation of rights letter requires that the insured reimburse a settlement paid by an insured when there is a finding of no duty to indemnify, even after defending the insured, because the duty to defend is greater than the duty to indemnify. Massachusetts Bay Insurance Company, MBIC, sought reimbursement of $2 million that it paid under a reservation of rights to settle litigation brought against its insured Neuropathy Solutions, Inc. In MBIC versus Neuropathy, a April 3, 2023 decision of the United States Court of Appeal for the Ninth Circuit, the Ninth Circuit determined who owed the settlement payment. On cross motions for judgment on the pleadings, the district court held that MBIC had a duty to defend and indemnify Neuropathy in the underlying case called the Bernal action, and that MBIC was thus not entitled to any reimbursement. MBIC satisfied the prerequisites for seeking reimbursement of the amount it paid to settle the Bernal action on Neuropathy's behalf. To seek reimbursement under California law, an insurer must provide 1. A timely and express reservation of rights, 2. An express notification to the insured of the insurer's intent to accept a proposed settlement offer, and 3. An express offer to the insured that it may assume its own defense in the event that the insured does not wish to accept the proposed settlement. MBIC provided a timely and express reservation of rights and informed Neuropathy of its intention to settle the claims for $2 million policy limits subject to Neuropathy's approval and MBIC's reservation of rights. This letter also informed Neuropathy of its right to assume the further handling of this matter going forward if Neuropathy did not wish to settle the claims for $2 million. Neuropathy signed the settlement agreement on May 28, 2021. Contrary to Neuropathy's argument, MBIC gave Neuropathy sufficient time to consider the proposed settlement. Under California law, the insurer's duty to indemnify runs to claims that are actually covered, in light of the facts proved. By contrast, the insurer's duty to defend runs to claims that are merely potentially covered in light of the facts alleged or otherwise disclosed. Thus, the insurer's duty to defend is and always will be broader than its duty to indemnify. The Ninth Circuit found that the district court erred because it invoked the broader duty to defend standard, potentiality for coverage, to require MBIC to cover not just the cost of defending the underlying Bernal suit, but also the $2 million paid to settle it. To the extent that the underlying Bernal action falls within the coverage provision of the insurance policy, coverage is excluded under the policy's professional services exclusion. That provision excludes, quote, bodily injury, property damage, and personal and advertising injury caused by the rendering of or failure to render any professional service, advice, or instruction, 1, by the insured, or 2, on the insured's behalf, or 3, from whom the insured assumed liability by reason of a contract or agreement, regardless of whether any such service, advice, or instruction is ordinary to any insured's profession. The Ninth Circuit concluded that based on California case law, the insurance policy's text and the operative complaint in the Bernal action, Neuropathy's liability in the Bernal action fell within the professional services exclusion. because that exclusion extends to wrongdoing in the supervision and monitoring of others in the provision of professional services. And neuropathy incurred liability because of its provision of professional advertising and medical services, not inadequate record keeping or poor customer service. Finally, the complaint's allegation that neuropathy engaged in discriminatory marketing techniques and high-pressure sales tactics falls within the professional services exclusion for advertising services and health advice or instruction. Neuropathy's liability in the Bernal action was thus excluded from coverage as far as the Ninth Circuit was concerned, and MBIC was entitled to reimbursement of the $2 million it paid to settle the lawsuit from neuropathy. In my opinion, liability insurance provides a very broad duty to defend and insure that is more than the duty to indemnify. In this case, MBIC paid to defend its insured and properly gave the insured the opportunity to take over the defense if it did not want to settle. Neuropathy refused in the Ninth Circuit, finding that MBIC applied the law as required. It therefore required the insured neuropathy to reimburse the insurer for the $2 million it paid to settle the lawsuit. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog posting and receive notice of every blog posting, usually 5 or 6 a week, and you will also gain access to all 4,500 and more blog postings. You can also subscribe to the videos at youtube.com and at rumble.com. And if you watch these videos, I'd appreciate it if you click on the like button on YouTube and the Rumble button on Rumble. And also tell your friends and colleagues so that they also can subscribe to the blog and to the videos. You might also be interested in subscribing for more detail for a very small fee to my locals community and my Substack publications. Thank you for your attention.